It is my privilege today to address all of you and to share a little bit about IP in Malaysia. Now, today's talk carries the theme Navigating the IP Playground in Malaysia, and it serves as a background, as a platform for us to delve into the world where countries have become more technologically and economically intertwined with one another. Now, I will start off my talk with three very important letters, I, P, and R. Now, all of you will understand that that means intellectual property rights. So that's what we are here today to talk about. Now, IPR, we cannot run away from talking about technology without talking about IPR. And for foreign investments, foreign direct investments, to increase in a particular country, even in Malaysia, the IP rights regime is actually very, very important to attract foreign direct investment. Without a strong IP regime, we would not be able to attract people from investing into the country and from technology from coming into Malaysia. Now, as you know, technology changes very fast, so the laws of the country must also keep pace with the changes in technology. So in this instance, in the past decade, I would say in the past 10 years, Malaysia has been actively updating their laws. In 2019, for example, we updated our Trademarks Act. Just now, my colleague from the Malaysian IP Office has highlighted some of the amendments to the Patents Act, which came into force in 2022. Now, for Designs Act, for those who are interested, Malaysia has ratified the Hague Agreement, and amendments to the Designs Act will come into force probably in 2025. It is expected to come into force in 2025. Now, we talk about so many IP rights, but for today, I will just focus on two. The first will be patents. So in Malaysia, it takes about 2 to 4 years from their application for a grant. And Malaysia practices a worldwide novelty standard qualified by a 12-month grace period. This 12-month grace period applies to acts done by the owner or abuse of the owner's rights. Now, Malaysia also is a member country of the PCT, Patent Cooperation Treaty. Now, one of the most frequent questions that I normally get as a practitioner is, how do I expedite a patent application? Because a grant is most important to protect a patent in a particular country. So in Malaysia, we have 3 ways of accelerating the patent examination process. The first is the Patent Prosecution Highway, or PPH. I think many of you are familiar with PPH. I'll just go through the 3 modes. First, Expedited Examination Program, and ASEAN Patent Cooperation, which is ASPEC. Now, PPH. So PPH is where we have is a bilateral agreement with another country, where we accept the examination of a corresponding country as a basis for examination in Malaysia. At the moment, we have PPH with 5 foreign patent offices: Japan Patent Office, the EPO, the European Patent Office, China National Intellectual Property Office, Korea, and USPTO. Now, the second way is via an expedited examination program. So you need to fulfill particular criteria in order to qualify for the EEP. I will list out all the criteria here. I don't intend to go through them in very detail, but these are the list of grounds that one may use or one may take into account in applying for expedited examination from the Malaysian Patent Office. As a practitioner, some of the things, one of the more frequent reason is reason number 2, which is evidence of potential infringement or ongoing infringement proceedings, where we have written to the IP office to expedite the examination and grant, simply because we know that there is infringing activities in the country. The other one is ASPEC. I think many of you are familiar here, especially those from the Southeast Asian country. It's a work sharing group among 9 participating ASEAN members. I believe the only country which is not there is Myanmar. And Myanmar had just implemented their patent laws, if I'm not mistaken, last month or earlier this month. So under aspect, you can actually share research examination results between the participating officers to allow applicants to obtain corresponding patents faster. So this is very unique to Southeast Asian countries. So if this should be also part of your patent filing strategy, if you want to consider expediting your examination and grant in Southeast Asia, including Malaysia. The other aspect which is very important for when we talk about technology is trade secrets. Now, not everything can be protected by patent, and some there are trade secrets, the know-how. How do you protect it in Malaysia? Unfortunately, there is no specific law or legislation which governs trade secrets in Malaysia. So we use what in Malaysia we call the common law, which is the tort of breach of confidence. So you need to establish a few things for the requirements. Information sought must be necessary quality of confidence. Information was communicated in circumstances importing an obligation of confidence, and there must be an unauthorized use of that information to the party communicating it. Now, simply put, this means that the information that is confidential must be a confidential nature. Not every information is confidential. There must be an element of or a feature of confidentiality in the information. Now, it must be communicated to the other person in a way which denotes confidentiality. For example, if you have a document which contains very important technical information and you stamp it as confidential, that's one example of how it's communicated confidentially. And of course, there must be an authorized use of the information for the tort of breach of confidence to apply. The third one is contractual obligations. Since there is no specific legislation that governs trade secrets, one would definitely ask, so how do you protect trade secrets in Malaysia? I would say that contractual obligations are very important. So if you are a foreign investor thinking of collaborating with a local Malaysian company, for instance, or if you are in a JV, or if you are just engaging a manufacturing company in Malaysia, say for instance, and you are going to impart technical knowledge, which may be confidential or secret, then you have to make sure that when you enter the agreements, you have to have NDAs, non-disclosure agreements, or you have to have very good confidentiality clauses that are inserted into these agreements. That is, I think, one of the most essential ways to protect trade secrets. Now, having a contract is not enough. I believe there must also be good policies in place that ensures the confidential information is kept secret. For example, if you have a source code which is secret to you, then you need to limit the access of the source code. So all this again needs to go into the agreement, which sets out clearly what can be done or what cannot be done. And why do I say agreements are important? Because agreements can be enforced. NDAs can be enforced in Malaysia. Confidentiality clauses can be enforced in Malaysia. So contract is one of the ways to go to protect trade secrets, apart from using the common law tort of breach of confidence. The next thing we need to talk about is enforcement of IP rights. Now, if your IP rights are being breached in Malaysia, what do? Then, of course, civil litigation is one form of protection. Basically, you need to file a lawsuit in court for any infringing activities, for example, patent infringement, trademark infringement. We also have, for trademarks and copyright, we call it enforcement action. In this case, we lodge complaints with the Ministry, the Enforcement Division of the Ministry of Domestic Trade and Cost of Living, which is the ministry in charge of my IPO. The enforcement officers will then do a search and a raid of these infringers. So this is good to deal with counterfeit products which are in the market. Now, for enforcement action, it carries both civil and criminal sanctions. So the infringer, if found liable, could be fined or imprisoned, or both. Now, in the High Court, frequently many will ask me, how long does it take for an infringement case, a civil litigation case, to go through the High Court? We have a specialized intellectual property court in Kuala Lumpur, which hears only intellectual property cases, and it has a disposal rate of 9 to 12 months. So as you can see, it's actually quite quick. If you need something to be done even quicker, for example, you need an injunction to be placed before the trial starts, you can apply to the court for an urgent injunction. There's also this, we also have this injunction called an Anton Pillar order, which is basically a search and seizure order. Now this applies mainly to in trade secret litigation. That is very important, because nowadays you have a lot of information which is no longer in document form, but it's kept in cloud or it's kept on digitally. So Anton Pillar execution is very, very crucial to be able to preserve this evidence before it is deleted or destroyed. And arbitration. Arbitration is another way for, this is more relevant for, I would say, in a situation where you are collaborating with a local company and there's a dispute, and you do not want to go to court, but you wish for it to be arbitrated. So arbitration clauses, again, are very important to be inserted in your collaboration agreements, your joint venture agreements, your manufacturing agreements, so that if there is a dispute, parties can then choose a neutral venue and a neutral law for their dispute to be decided. Now, arbitration is also good when it comes to, when you do not want the proceedings to be public. Court proceedings are public, arbitration proceedings are private. Now, what to look out for foreign investor coming into Malaysia for the first time? If you do not have patent or trademark and you wish to exploit your invention or your goods in Malaysia or sell your goods in Malaysia, first thing to do your due diligence, do clearance searches to make sure that whatever you are doing do not infringe anyone else's IP rights. It is possible that your trademark may have been registered by some other person, or there may be another patent out there which scope covers your invention. So be very mindful of these. Clearance searches are very important. Licensing. Licensing is another way, is another aspect of what you should look out for. I will come to that very quickly, including cross licensing. Now, licensing is where the IP owner grants permission to another party to exploit the IP. I think most of you are familiar with licensing. It allows the IP owner to control how IP is being used or exploited. Are there disadvantages? I would say yes, because once you license up your technology or your rights, IPRs, basically you lose a little bit of control over how the IPR is being exploited. You worry that your partner may use the information to come out with competing products, for example. You worry that the quality of the products that come out, they are being manufactured by your partner, are not to the standards that you want. But all these can be controlled by using a very good licensing agreement. That's how you mitigate the risk. You have a very good licensing agreement in place, and the licensing agreement, most of the time, you will imagine, you will talk about how you want your IPR to be exploited. But many people do not think about what happens after the licensing agreement ends. So that is where usually we run into a lot of issues. For example, when the license agreement ends, what happens? What happens to the product or the technical information? Do you get them returned to you? And what is the exit period? These are the things you have to think about when you exit a licensing agreement. Most of the time, that is where litigation will come in, where parties cannot agree as to how the relationship will terminate. It's very good when you start off a relationship because everyone is happy. But when you terminate or end a relationship, that is where you run into a lot of disputes because everyone is angry with each other for failure to fulfill obligations. Likewise, for collaboration with parties, you talk about cross-licensing. So you have two companies which have their IPs and they come together to say, let's jointly develop the product. But how do we decide who owns the IP rights? And what happens after you have a product which comes into place, a new product that uses the technology of both parties? What do we do with it? So that's where you cross-license the IP. The same considerations will apply as you talk about licensing as well. You need to set out clearly what are the terms of the license, how parties are going to divide income, royalties, and what happens when the relationship comes to an end. Who owns the IP to the product? Ownership of the resulting work. Who owns it? This is obviously a very sticky point. Both parties will say, I want 50%, the other party will say, oh, I also want 50%. But remember, you're no longer in a relationship. So how do you then work it out? Who owns the work in the end? One solution is joint ownership. Let's have joint ownership. Now in Malaysia, joint ownership laws for IP are not very well set out in the IP legislation. So you may have parties saying, oh, each of us own 50%, but that does not necessarily mean you get 50% of the income or the royalties that come with the exploitation of the IP. So all this must be set out very clearly in the agreement as well. How you want the IP to be owned. And also, as you talked about earlier, the dispute resolution clause must be there so that parties know if they were to litigate or if they were to resolve a dispute, what is the mode of resolution. Now, for those who want to establish a presence in Malaysia, there's a multitude of factors to consider. Unfortunately, we don't have one single overarching policy that governs all foreign investments. It depends on the type of business you want to enter into. Some of the factors you want to consider is local equity versus foreign equity participation. We still have laws in Malaysia which requires a certain percentage of local equity. Now, you also need to consider whether you want to incorporate a local company, and if you do, what the specific capital and infrastructure prerequisites. The paid-up capital, and also adherence to financial regulations. Now, I am not an expert in this, I have to admit, I only do IP law, but these are some of the factors that if you want, you really need to speak to a local lawyer or local consultant who is very familiar with these requirements, because as I said, each industry has different requirements, so you have to be very careful with that. There are also tax incentives which are available for foreign investors. So high-tech industries, you can get pioneer status, you can get tax exemption for up to 15 years. And there are also investment tax allowance. Again, it depends on the type of industry you are in. So if you are, for example, in biotech or pharmaceuticals or alternative energy technology, you may then think about applying for pioneer status. You may wonder what is the connection between tax and IP. Without these tax incentives, you would not want to venture to invest in a particular country. So apart from IP, you also want to think about how you want to structure your business in Malaysia, how do you want to protect your IP in Malaysia, and how do you choose to enforce it. You remember I started off my talk with three letters, I, P, and R, which means intellectual property rights. It also means this, investigate before investing. So this is where due diligence comes in. You must investigate, you must look into clearing searches, you must think about doing due diligence on your JV partner or your collaborator. proactive in your protection. Now, apply for your patents. If it's trade secrets, you cannot be protected by any legislation. Contracts, think about your contracts. Think about how you want to license, cross-license, ownership of IP, duration, income stream. Think about all those things. Be proactive. And lastly, be robust in your enforcement. You may have a very good contract in place. You may have a patent which is granted in Malaysia, but if you do not choose to enforce, or if you are not robust in enforcement, then the infringer will then say, well, he is not going to do anything about it, so I'm going to continue infringing. So be robust in your enforcement. Send a message to the infringer that you take your IP rights seriously. Thank you very much for giving me this time to share a little bit about IP in Malaysia, and I'm happy to take any questions during the Q&A. Thank you.